Good morning, everybody, and welcome to this program on probate court basics. My name is Paul Knierim. I'm a lawyer with Topeka, Daly, Pope, and Perry, and I'm glad to have all of you here joining me. You've got my bio, so I won't bore you with details. Suffice it to say that I've been in the probate world for over 30 years at this point, and I've been on both sides of the table, both as a practicing lawyer and as a probate judge. So my work is, I describe it as all things probate, everything from estate planning and estate settlement to litigation, both in probate court and superior court. Now, it's a little bit awkward not being able to see you today, and I wish I could, but it's certainly a sign of the times that we can't be actually together, but it's nice to have the technology that we can communicate and have this session even under these circumstances. It reminds me a little bit, some of you may be of the age where you remember the Brady Bunch, but there was an episode where Jan had an important presentation at school, and she was at the breakfast table, soon to depart for school, and feeling very nervous about the presentation. And her dad, Mike Brady, gave her that age-old advice of, well, just imagine that your audience is sitting there in their underwear. That should make it less intimidating. Now I give this presentation knowing that you're in your homes, that there's a very real possibility that you are sitting in your underwear or your pajamas or whatever. My point is simply, I hope you're comfortable, and I hope this program is of value to you. A couple of housekeeping remarks here before we get started. This is a listen-only webinar, which means all of you are muted, but you are able to ask questions at any point, and I encourage you to do that. The way to ask your questions is to type them in the chat box over on the right-hand side. And we have things set up so that it's a private chat. You and I are the only ones who are going to see your questions. They aren't presented to the whole group. What I will do is pause periodically during my presentation to look at the questions, but you should feel free to type them in anytime so that when I do have such a pause, I'll be able to look at your questions and get to them right away. Let's go to the first slide here. The program, as you know, was billed as probate court basics. I want to start just by giving you an overview of the topics that I intend to cover today. First, I'm going to talk some about the probate court system as an institution, a little bit about its structure, its people, and its history, just so you have a sense of what the probate courts are and how they operate. Secondly, I'll describe an overview of the types of cases that the probate courts handle. And I suspect that you'll be surprised about some of the things that I'm going to tell you about. Most people don't realize all of the various responsibilities of the probate courts. Most people think decedents' estates, but there's a lot more that the probate courts do, and I'll talk some about that. Next, I will focus on two types of cases, conservatorships and decedents' estates, because those are the kinds of cases that most families, many families, are likely to encounter in the probate court system. And lastly, I'll talk about avoiding probate. You can't really talk about the topic of probate without also addressing people's feelings and desire to avoid probate. So we'll spend some time on that, and we'll talk about how, with your own estate planning, you can take steps to avoid probate. Now, remember, you should feel free to type in your questions at any point so that I can see them. And as I said, I'll pause periodically so that I can answer them for you. Connecticut's probate court system has changed quite a bit over the years. Today, as we speak, it consists of 54 probate districts. So the state is divided up into 54 regions. And in fact, most of the probate courts serve an area of towns. They are regional in basis, and that's a change that took place. I'll talk about this in a moment. It's a change that took place in 2011. So as an example, I work in the Simsbury office of the firm, and the Simsbury Regional Probate Court now covers 4 towns: Simsbury, Avon, Canton, and Granby. And most of the probate districts around the state serve a variety of communities in a cohesive region. Probate judges are elected to their offices, and they serve for 4-year terms. They are the only elected judges in the state. All other judges of the Superior Court, the Appellate Court, the Supreme Court are appointed by the governor and approved by the legislature. The notion, the philosophy, it seems to me, behind probate judges being different and being elected is a very strong desire to have the judges connected to the community and the families they serve, and to be very responsive to the needs of the individuals who require the services of the probate courts. So that local elective aspect of the office is a strong influence in the probate court system, and it's part of the work ethic, if you will, of probate judges. Another aspect of the probate court system that keeps it close to the people we serve in the probate courts is that our cities and towns are the hosts for the probate court facilities. Most of our probate courts are located either in city or town hall, and in some cases in another municipally owned and operated building. For example, there are a number of courts that are located in the same building as the senior center in town, which makes a lot of sense given the work of the probate courts. And then a small minority of courts are located in rented commercial space. But even when that's the case, the municipalities are actually paying the rent for that facility. So there's a close tie, a partnership between the courts and the communities that the courts serve. You'll see on the slide, I've used the word approachable. And what I'm driving at there is that probate courts, the judges and court staff both, strive to be user-friendly. The word court in and of itself is intimidating, and nobody loves the idea of going to court, I suppose, maybe just lawyers. But for most people, it's something to be avoided. But the probate courts try very hard to be an atmosphere that's not intimidating, that's friendly, and that doesn't have all the formalities, not all the trappings of traditional courts, at least the ones we see on television. So, for example, probate judges don't wear robes. Most of the courtrooms look like the one you see on the slide here in that image. It's a conference table as opposed to a raised bench where the judge at a higher level than the people. Many of our courtrooms look exactly like that image that you're seeing. In fact, that looks a lot like my former courtroom in Simsbury. It had a window just like that behind it. It's a local regional system intended to be easy to get to and accessible from a personal standpoint also. Something else that I think is notable about the probate court system is that its funding is principally from the fees that the courts charge for the services provided. And I'll talk some more about this later on in a bit greater detail and give you some examples. But the important point here is that unlike the rest of the judicial system in Connecticut, which is funded from taxpayer dollars from the state's general fund, probate courts collect 90% of their revenue from probate fees, with the remaining 10% coming from the state budget. One last comment about the probate courts relevant to today's situation is that the probate courts have proved themselves to be quite nimble in dealing with the requirements of social distancing and the COVID-19 crisis. Probate courts are trying very hard to be able to still move business despite the restrictions. And they're using things like phone-in hearings, or in some cases, even video hearings, so that the parties can participate and the business at hand can move forward. So I'm not part of the probate court system anymore. That was my prior occupation 20 years before, the past 20 years, I should say, before joining the firm. But I'm proud of them. I think they're handling the situation, the judges and staff alike, in a very proficient manner. Probate courts have a long history. In fact, they're the oldest courts in the state of Connecticut. The first 4 probate courts were established in 1698. So think of that, before the Revolution even, we had probate courts handling some of the judicial business of the state. And for most of the history of the system up until very recently, the trend was toward establishing more and more probate courts. So as the state population grew and the suburbs grew, the legislature from time to time would add additional probate courts. And I think by 1987, we topped out at 133 probate courts, as distinct to our current number of 54. The system was also, for much of its history, quite decentralized. So we had locally elected judges doing their jobs. There wasn't really much of a central apparatus. So there were significant variations in how each of those courts did its business. But beginning in 1949, with the establishment of the Connecticut Probate Assembly, the trend began towards greater uniformity and consistency among the courts. So the Probate Assembly was an organization of the judges, voluntary association, where they got together and tried to work on things like having the same forms apply for all of the courts across the state. In 1968, the legislature took an even stronger step in that regard and established what we call PCA, Probate Court Administration, and that's the central office for the probate courts as we speak today. And my former role as probate court administrator meant that I was simply the administrative head of the system. And with PCA, there's a lot of effort put into, establishing uniform rules. We have rules of procedure that apply in all the courts. The forms, likewise, are the same throughout the system. There's a rigorous education system in place for both judges and court staff. And when it comes to things like making sure our law is as up to date as it possibly can be, probate court administration plays a lead role in proposing legislation to accomplish that. 2011 was a watershed year for the system. There were significant financial troubles. It appeared that the system, without significant restructuring, was at risk of bankruptcy, in fact. And the legislature stepped in, worked in collaboration with the judges and the cities and towns to consolidate down to the current 54 districts. There were a lot of other significant improvements that came with those 2011 changes, including the finances of the system were centralized, so everything now is budgeted through probate court administration. And there's a uniform compensation and benefits plan for court staff, for example. Judges since 2011 are required to be attorneys, and many other changes, all geared toward strengthening the professionalism and the expertise of the system. Now, the pie chart that you see on the screen now illustrates the various areas of jurisdiction that the probate courts handle. Now, what does that term jurisdiction mean? That's just a legalese word for responsibility or types of cases. So these are the categories of cases that the probate courts handle. And I might add that the way cases become the responsibility of the probate court is the state legislature. It's the General Assembly that decides what it is probate courts handle. I think of probate court jurisdiction, even though there are a lot of slices in this pie, I think of the jurisdiction as consisting of 3 principal areas. So I'm simplifying a little bit, but here's how I always see it. The right-hand side of that pie chart, decedents, estates, and trusts. That's what most people think of when they think of probate courts. That represents the largest single category of cases in the probate courts. I'll talk about that more in a minute, but it's the oversight of what happens to a person's property when she or he passes away. The second category, not well known, I don't think, is children's matters. The probate courts handle a variety of very important cases involving the welfare of children. An example is guardianship. So if a minor child under the age of 18 doesn't have parents, if both parents have passed away, for example, it's the probate courts that appoint someone else to serve as guardian. The probate courts are also involved in abuse and neglect cases. Sometimes there is a parent, but he or she is incapable of caring for the children. Oftentimes it's due to situations like mental illness, addiction, incarceration, the kinds of social problems we certainly know plenty about, but may make a person unable to care for a child, in which case the probate court has the power to remove that parent as guardian, either temporarily or permanently, as the case may be, and appoint someone else to serve as guardian. Probate courts also handle adoptions and paternity cases, establishing who is the father of a child when there is a question about that. And also sometimes a pretty common kind of case, if a child comes into some money, either let's say an inheritance, or perhaps a child is involved in some kind of an accident and there's a personal injury settlement, a person under the age of 18 can't hold legal title to property, so we need a guardianship of the estate, someone to handle the finances for that child. In most cases, it's the parents who serve as guardian in that role. So that's the second category of cases. Now, the third category of probate court cases I call incapacity. By that, I mean the case is about an individual whose capacity is diminished for some reason, due to some disability. That might be a senior citizen with dementia, or it might be a young adult with intellectual disability or autism, or it might be a person with mental illness who needs treatment that is perhaps that treatment's on an involuntary basis because the person doesn't agree to it voluntarily. So there's a court case about whether the person should be compelled to have treatment in a psychiatric hospital. So those are all different subcategories of incapacity, but the point is the probate court has a role in first determining whether the person is incapacitated, and then secondly, deciding how it's going to be handled. Will a person be appointed on behalf of that individual to help them with their affairs, either a conservator or a guardian, or will treatment be ordered so that they receive proper care? There's one last category. I guess I'll say it's my fourth category. That's miscellaneous, because from time to time the General Assembly asks the probate courts, or maybe I should say tells the probate courts, that there's another area of responsibility that they're going to handle. And my next slide is an example of one of those. Very apropos of the current situation, the probate courts for many years have been assigned the responsibility for handling appeals from quarantine and vaccination orders. Now, couldn't be more relevant than today, right? To think about public health emergencies associated with a virus or some other threat to the public health. Now, we've been operating under executive orders. As you know, the governor has issued lots of different instructions and rules, and in some cases advisories, about things like social distancing and closure of businesses. To my knowledge, none of those orders have been challenged in probate court. And it's probably because when it comes to things like the stay-at-home advisory, it's just that, it's an advisory. But the law does provide for the governor, working in tandem with the Commissioner of Public Health, to actually issue orders requiring people to be quarantined that are legally binding. And under that same statute, an individual subject to that order has the right to take an appeal to the probate court as to whether that quarantine order is appropriate or not. And it's a rather elaborate procedure. The probate court will appoint an attorney to represent the individual because civil liberties are at stake, and the court will hold formal hearings. Part of the reason why the probate courts, I mentioned this before, are nimble in handling the current situation is because the probate courts are prepared for pandemic situations where the courts might have to conduct hearings that can't be in person because of the contagious nature of the illness that is causing the underlying cause of the quarantine order in the first place. Lastly, I want to emphasize something, as you can probably tell from my discussion here, the probate courts are near and dear to my heart. I think they perform a very important function in our communities. Here, what I want to identify is that it's a social service role. We think of probate courts as being part of the legal system, and of course they are. But equally important is what vital role the probate courts have in helping people, some of the most vulnerable people in our society, get the assistance that they need. All that work in the area of children's cases, for example. Many of those cases involve a child who has need for better support and better care. And if not for the probate court, one of the specialties of the probate court is having family members step into the roles when needed. So guardianship cases, for example, when a parent's unable, most often the court-appointed guardian is a grandparent or maybe an aunt or an uncle, family stepping in. Same is true of conservatorship cases. Senior citizen who needs support and assistance because of an illness, it's most often going to be the adult children who are stepping up. But the probate courts have an important role in empowering those family members to have the tools they need to be able to care for their loved one. And part of my job when I was administrator was to advocate for funding at the General Assembly. And it's a point I always tried to emphasize, that without the probate courts, the various state agencies would have a lot more work to do, precisely because the probate courts are able to help families help themselves. This is a good time, I think, for me to pause for questions. Let me just take a look and see if there are any questions I can address. So I have a question here. It is, does the law require probate court judges to have a legal background, for example, a JD degree? And the answer is yes. Thank you for that question. Since 2011, in order to run for probate judge, an individual has to be admitted to the bar in the state of Connecticut, which is just another way of saying they must be a licensed attorney in the state of Connecticut. That requirement was not in place until 2011. And before that time, we had a significant percentage of the judges who didn't have formal legal training. They had lots of training within the probate court system, but they weren't attorneys. So thank you for that question. I think that's it for now. So I'll move on, but please feel free to ask your questions, and I'll pause again and take a look and see what questions I have written down. All right, so that was our overview of the probate court system, the structure of it. Now let's focus on two kinds of cases that if a family is going to encounter probate, I would say it's most likely that it's either a conservatorship or a decedent's estate. You saw all the other things, but in sheer numbers of cases, there are more conservatorships and estates than anything else. So let's talk conservatorship first. Conservatorship, that's a long legal word too. I keep coming up with those. Another term that maybe is a little easier to understand that's a synonym for it is adult guardianship. The idea here is to provide a framework to assist a person who's unable to manage his or her own affairs. So we all kind of understand what guardianship is for a child. That's the role the parents play, or a court-appointed guardian if the parents cannot. Conservatorship is a similar parent-like role for an adult who, due to some disability, can't care for himself or herself. Now, I have some acronyms there on the screen, COP and COE. That's just shorthand for the two kinds of conservatorships that we have here in Connecticut. COP stands for conservator of person. COE stands for conservator of estate. And those kind of cumbersome terms simply mean the conservator of person handles the personal affairs, medical, housing, things like that, of a person under conservatorship. Conservator of estate is responsible for finances. Sometimes a person needs one of those, not both. Many times a person needs both forms of assistance. And one conservator can serve both roles, but on occasion, there's reason for a judge to appoint different individuals for each of those roles. So intellectually, they are distinct, and it depends on the individual circumstances exactly how it is arranged. Now, what I like to say about conservatorship is that it is both an awesome responsibility and an awesome set of powers. And by awesome, I mean a very high level of duty and responsibility. A conservator is charged with arranging the affairs of a person who can't do that for himself or herself. So if you think about a person with Alzheimer's disease, for example, and the range of needs that person has to provide comfort, care, medical treatment, the payment for those services, the housing or the home health care or the skilled nursing arrangements, there is an awful lot of responsibility involved. And accordingly, the law provides a good deal of power and authority in the person of a conservator. Because the role is so powerful, the procedures associated with conservatorship are strict and formal. The underlying notion being no person should have a conservator appointed for him or her unless the need is very real. And we've gone through a process where a court hears actual evidence that the person does not have the ability to handle things on their own. So among the elements of the conservatorship proceeding are case doesn't go forward without a recent report from a Connecticut licensed physician that details the medical condition and its impact on the individual's mental functioning. There's a formal hearing. The court always appoints an attorney for the individual involved. And in fact, if the person is unable to afford those services, the probate court system pays for the attorney to represent the individual. We want to make sure that the person has an advocate on their behalf so that if they oppose the conservatorship, someone's there to present their case and present evidence as to why it's not necessary, or to present evidence on who the conservator should be. Sometimes there are disputes about who's the most appropriate conservator. If the court decides that a conservator should be appointed, that conservator is then subject to continuing probate court oversight. The conservator, if we are talking about a person handling finances, has to file a probate bond. That's sort of like an insurance policy on the activities and performance of the conservator. They file an inventory. What are the assets? In the first year, they file a financial report at the end of the year, and then thereafter, once every 3 years, a financial report to tell the court how the conservator is handling the finances. There are also strict rules about things a conservator can't do without going to court first and getting prior court approval. And examples you see there on the screen would be changing the individual's residence. So moving a person from their home either to another home or to a facility requires a formal court proceeding. Likewise, the administration of psychiatric medications is something that requires probate court approval. In the interest of time, I'll go rather quickly through this slide, but I just want you to know, because I think it's important, that our state has been a leader in the efforts to reform conservatorship and mostly to improve the support and oversight of conservators. I said before, it's a huge job, awesome responsibility. Family members are thrown into this with all that responsibility, and we want to do the best we possibly can to make sure that they get proper training and oversight to make sure that they know how to do their job. And if there's an error, we try to nip it in the bud before it becomes a real problem. Our state instituted random audits for that very purpose of conservators about 2 years ago, so that in addition to the reporting that's made to the court, they face from time to time the scrutiny of an even more in-depth look at how they've handled finances. Last thing I want to say, and this is a very important point to me, is modern conservatorship today tries to focus on the conserved person's preferences. It used to be we thought of conservatorship as what's the best interests of the conserved person. And of course, that's still a concern. We want to make sure everything that a conservator does is in the best interest of the conserved person. We're also training them that they should always be trying to involve the conserved person in decision making, learn the person's preferences, and to the maximum extent possible, act in accordance with those preferences. Let me pause here for questions and see if there's anything I can answer about what I've covered so far. The first question is a good segue to where I'm going to go. The question is, my understanding is that as long as a durable power of attorney and healthcare directives specify, we would be covered. And that's a good point. I'm going to talk about that when I cover avoiding probate in just a moment. Next question is, what's the difference between a conservator and a power of attorney? Another great question. I think of the difference this way. A power of attorney is a private arrangement. So you, working with your attorney, sign a power of attorney document that specifies who your agent is acting under that power of attorney. And it also specifies what powers they have. That arrangement is private, doesn't require court supervision, and unless something goes wrong, there is no court involvement. Conservatorship, on the other hand, is a more public arrangement, and it is a court-supervised one. So the conservatorship happens only if a petition is made to a probate court to appoint a conservator. And then, as I've just described, the court has an ongoing supervisory responsibility and is looking over the shoulder of the conservator to see how he or she is performing. Another question is, if a spouse becomes incapacitated, is seeking a conservatorship required? Well, this relates to the prior two questions, so you're all on the same track, and I think that's great. There's never, I should say, a mandate for a conservator to be appointed. It depends on each individual's circumstances. A spouse has certain inherent authorities with respect to the other spouse and healthcare issues. That said, the best planning is to have a power of attorney and healthcare instruction in place as between spouses, so that when you're dealing with third parties, whether it's a medical provider or a financial institution, the authority of the other spouse to act on behalf of the person who's ill is very clear. All right, in the interest of time, I'm going to move on. We'll have more opportunity to answer questions, and I'll try to get back to any questions I wasn't able to address just now later on. But let's shift now to the other category of case that most families, I guess I'm going to say all families, will face in some way at some point in the lifetimes of the members of the family, decedents' estates. So if we were live and in person, I'd ask for a show of hands on this question, and I'm not going to be able to see whether you raise your hands or not today. But who out there thinks that every estate needs to go through probate in Connecticut? Okay, my mental telepathy tells me that most of you raised your hands, and good for you. You've answered correctly that in Connecticut, in fact, every estate needs to go through probate. Whatever planning has happened, even if there's been avoiding probate planning, every estate goes through the probate process. Now, here's a little more detail on that. There are 3 different pathways that might be involved depending on the circumstances of the person who passed away. So the traditional full estate is what we think of with decedents' estates. This is where if there's a will, it's admitted to probate and an executor is appointed, or if there isn't a will, an administrator is appointed to handle the estate. And as we'll talk about in a moment, the court will go through a series of steps in the oversight of that estate until we finally get to a final financial report and distribution of the estate. More on that in a moment. The next pathway that might be applicable is known as the small estates procedure, or some of you may have heard of it referred to as affidavit in lieu of administration. That's what lawyers and probate courts often refer to it as. This is a procedure under statute that applies when the solely owned property of the decedent is less than $40,000 in value. Important proviso here is you cannot use this procedure if there is solely owned real estate. Now, important to emphasize, a decedent's assets can pass in a lot of different ways. You know that, right? Joint ownership, joint survivorship, transfer on death, property held in trust, for example. All those are examples of property that passes outside of probate, and so it wouldn't count towards this $40,000. Likewise, if the house is in joint survivorship, it also wouldn't count towards the restriction that this is a procedure that doesn't handle real property. But this is a shortened procedure. No executor or administrator is appointed. And I'm oversimplifying here a little bit, but it's typically used to reimburse individuals for expenses they've incurred that are associated with the decedent. The prime example being the funeral bill. So if the assets of the decedent are relatively modest, it might even be less than, and I'm speaking again here, solely owned assets, they might be less than the value cost of the funeral. And so the probate court would simply order distribution of an asset to the person who paid the funeral bill as reimbursement. Finally, the third avenue here that catches those who have done everything possibly to avoid probate but still find themselves having to make a filing is what's referred to as tax purposes only. Here, there's no need to use the services of the probate court to transfer assets. In the prior 2 categories, it's the authority of the probate court that is enabling the family to ultimately distribute the assets to the intended recipients. In a tax purposes only estate, there are no solely owned assets, no probate assets that need probate court services to be transferred. And that's presumably because they're all passing by some other means, whether it's joint accounts or TOD accounts or beneficiary designations, trusts, etc. It's all passing by other means. The catch is that estate still needs to file a Connecticut estate tax return with the probate court. Hence the term tax purposes only. Now I want to emphasize here, Connecticut at this point has a pretty high exemption from the estate tax. Each individual this year has a $5.1 million exemption from state of Connecticut estate tax. So the vast majority of estates aren't subject to the estate tax. Despite that, every single estate has to file an estate tax return so as to establish that it's under the exemption if it is. But there's another important aspect of this, which is the probate court will calculate its probate fee on the basis of the assets reported on that tax return. Remember, I said back in the beginning that probate courts are 90% funded from probate fees. Well, the engine of that revenue source is decedent's estates and the fees that we're referring to right now, the probate fees. Important point is that probate fees apply to all of the decedent's assets, whether or not they're passing through probate. So in my probate judge and administrator years, people would often say to me, that doesn't seem fair. Those assets aren't using the services of the probate court. Why should people have to pay the probate fee? And the only way to answer that really is to say that it's a tax. It's the state of Connecticut's system for financing the probate courts. And I think the attempt was made here to have it be even-handed and be the same amount of fee regardless of how individuals have arranged their financial affairs. So let's take a quick look at the procedures that are involved in a full estate. Remember, that's the first category I mentioned, and the traditional way that estates are handled. In a full estate, the first question is whether there was a will or not. A person who dies without a will is referred to as intestate. The opposite is true if you have a will. It's testate. Here again, I'd ask for a show of hands as to whether people agree with me that everyone needs a will. And I'm sure you've all raised your hands on that question. If you're connected with Topeka Daily Pope and Perry in any way, you know that every person needs a will. That's important. Once we get past that hurdle, the probate court will either admit the will to probate, I'm not talking contested matters now, let's say there's no objection, and appoint the executor who's named in the will, or it'll appoint an administrator if there was no will. The estate then goes through a series of steps. First, the executor reports what the assets are, that's the inventory. Then he or she tells the court what the debts or claims were. They file a tax return, as I've just described. And at the end of the process, they file a financial report that says how they've handled the estate and how they propose to distribute what's left after the estate administration process. Typical estate administration is a 6 to 12 month process. It can be faster if it's that small estate's procedure. And if it's a taxable estate over that $5 million mark, expected in most cases to be longer because the tax authorities, Department of Revenue Services or the IRS, are going to take a closer look, and they generally don't get that done quickly enough, so it tends to be a longer process. The experience of the probate courts is that most estates are uncontested. It's more of an oversight process to make sure, pardon me, that the executor administrator is doing the job correctly. But a minority of cases involve disputes, and as you might expect, it's that category of case that consumes most of the time of the judges. Now, this isn't a webinar about contested probate cases, but I thought I'd maybe just mention some observations from my years in the probate court system about what drives those contested matters and what the themes are. One thing, and I say this really quite distressed about it, is that elder exploitation is on the rise, or at least we're realizing it more and more. Partly that may be the effort to raise awareness of this problem, but it is a very significant problem. We see both in conservatorships and in estates situations where a person is trying to take advantage of the senior, either taking advantage during their lifetime by misappropriating assets or by unduly influencing them as to the provisions of their will or how they arrange their various accounts and beneficiary designations, maybe to favor one individual over others. It's quite shocking, really. And the statistics tell us that the primary source of that exploitation is family members. In sheer numbers, it's a family member taking advantage of the situation. But it's not exclusive to that. It can be trusted advisors. I can't tell you how distressed I am when I see reports of attorneys who have abused their influence and stolen from elderly clients or clients with disabilities. And unfortunately, we read about that in our newspapers. Accountants, even ministers, there have been cases in our state where there's been exploitation. So that certainly is one source. Sibling rivalry is a major theme in the probate courts. And when it comes to will contests and disputes of that nature, I would say that the relationships among brothers and sisters are source number one of disagreements and hence litigation. Likewise, second marriage situations is another category where a married couple from prior marriages, each of them have children. There are dynamics associated with those relationships that give rise to a fair amount of disputes. And the only reason I raise these in our discussion today is to point out the fact that careful planning is warranted in these situations because there are tensions inherent in the relationships. Let me take a quick pause now and see if I have any questions. First question on my list is, what are the probate fees, and is there a sliding scale based on the amount of assets? That question supposes the answer exactly correctly. It is based on the value of the assets. And oversimplifying here, because it's a little more complicated than this, if you figure on 1/4 of 1% of the value of the assets being the basis on which the probate fee is calculated. And keep in mind, as I say that it's all the assets, whether they pass through probate or not. So just to give you an example, to give you a feel for it, if the probate estate is valued at $500,000, the fee would be a little less than $2,000. Keep it in perspective. All the way on up to the maximum fee is $40,000, and that applies to a $9 million estate. So it's a percentage based on the value of the asset. So I have a question here. Can a smart estate path be taken if the decedent's home is covered by a TOD deed, transferring the property to one or more beneficiaries? That term TOD, thank you for the question, is referring to transfer on death. That is a form of ownership whereby the property on the death of the owner passes to the individuals who are designated in the TOD registration to receive it at the time of death. Currently, Connecticut does not provide for TOD registration for real estate. We do have a statute that permits it for investment accounts, stocks and bonds, but at present it's not provided for real estate. One comment that I'd make is these can be handy tools, and they're attractive to people because it bypasses probate, and the asset can therefore pass instantly at the moment of death to the designated beneficiary. I will say, however, that great caution is warranted, because sometimes you've got an estate plan that's in place that says one thing, and then a beneficiary designation or TOD registration that happens at another time that may be inconsistent with the estate plan. So my bottom line advice would be, make sure you consult with your attorney on the registration of assets, joint ownership, and beneficiary designations, all of those things, because they need all to fit together into one cohesive plan. There's one more question before I move on. Is there a specific time frame that probate must be completed in? Well, when an executor or administrator is appointed, the decree that the court issues will actually say, complete this settlement within 12 months. That, however, is a guideline, not a hard and fast rule. And the courts recognize that sometimes there are circumstances where not everything can be finished in the course of 1 year. An example would be if there's litigation. Sometimes the death was caused in an accident, for example, a car accident, and there may be a lawsuit to recover damages for the wrongful death, and that might take a few years. So courts are flexible with the circumstances, but the probate court system is geared toward prompting an executor administrator to complete things at the 1 year mark if they haven't already by that time. All right, so let's talk now for a little bit about avoiding probate. Now, I often say to the judges that you'd be hard pressed to go anywhere in the state of Connecticut and talk with a group of people and have anybody disagree with the premise that they should avoid probate. It's an attractive notion that most people have heard the term and it resonates. Most people think it's a good idea. And fundamentally, I think it's about who wants to go to court at all. That's never viewed as a good thing. And over the decades, we've all heard horror stories about probate cases gone bad. Now, my view is that doesn't make the probate court system bad. Sometimes it has to handle very tough cases. But nonetheless, I recognize that people have a desire to plan ahead as much as they could. And there are some excellent tools that you can use to accomplish those goals that can be very beneficial to the individual and to the individual's family alike. Before I talk about a couple of those things, though, I want to emphasize what is actually accomplished by avoiding probate and what isn't accomplished. So good objectives that are achievable with advanced planning are planning ahead for your own incapacity. So we think a lot about wills, what happens to my stuff if I pass away. But incapacity planning is what happens with me and my stuff. How are my finances managed? How is my care managed if I'm not able to make decisions or execute on those decisions myself? It also accomplishes going through the probate process per se and the steps that I described. Now, that's a process designed to give structure and oversight, but one can accomplish that in a private setting, not subject to court supervision, if that's suitable for the family circumstance. And lastly, privacy can be accomplished. The probate courts, because they are public institutions, are open to the public. Not that citizens generally come in and observe probate court hearings, but the fact of the matter is, I can go into a probate court and look at a file if I want to, so long as it's not a specific confidential case type, such as children's matters. I do want to emphasize, however, don't be misled. Don't be oversold on the notion of avoiding probate. It will not lower your taxes. There is nothing special about probate avoidance that can reduce estate and other taxes. And as I mentioned a moment ago, it doesn't lower your probate fees because the fee will apply regardless of how you've arranged your assets. So let's just talk about 3 important tools to consider if your objective is to avoid probate. First and foremost is the living trust. Now, as the name suggests, it's a trust that you establish during your lifetime. And it means that you can convey assets into that trust during your lifetime also. The good part about that is it plans both for death and incapacity. The trust, rather than your will tell the person who you've given authority to handle things how to distribute assets on your death. But the trust also can tell that trustee how to handle things if you're not able to do that yourself. So a living trust is an excellent tool, and it can serve many, many objectives. In fact, we could have a whole seminar, and our firm does, in fact, have whole seminars on trusts alone because it's a complex subject. But think of some of the objectives that you can achieve by way of a trust. You can provide structure for young children or young adult children in how they receive assets after your death. You can protect children, adult children, from marriage gone bad or from financial troubles or bankruptcies. You can plan for family members who have special needs to ensure that there are funds to help them while they're still able to receive public assistance benefits that they are entitled to. It might also be a good tool if you have out-of-state real estate to avoid multiple probates. So again, this could be a seminar in its own right, but it's a good thing to consider towards the objective of avoiding probate, but more importantly, planning both for incapacity during your lifetime and disposition of your assets after death. I'm going to skip the trust code right now because, like I said, that's a seminar in its own right, and mention power of attorney. Now, we had a question on that earlier, so I'll touch on it briefly. The power of attorney is a means by which you can designate an agent to act on your behalf with respect to financial affairs. So they can do, for example, banking, investing, real estate transactions on your behalf. This is a very powerful document. I'm glad that power is in the title, because when deciding whether to use a power of attorney, and more importantly, who to designate as your agent under that power of attorney, it's essential to understand that the person fundamentally can do for you anything that you could do for yourself. You can craft a power of attorney with more limited powers if you choose, but a broad-based statutory form power of attorney, again, makes your agent able to do just about anything, including changing the title to how you hold assets, changing beneficiary designations. They can't modify your will, but they can actually modify a trust if you've invested them with that level of authority. So it's a good tool to plan for incapacity because it means someone can take care of things on your behalf. But bear in mind that it's very powerful. And when I talked previously about contested matters, we do see sometimes exploiters use powers of attorney as a means to carrying out that exploitation. And finally, a tool in your arsenal to avoid probate are to have healthcare directives in place. So first and foremost among those would be an appointment of a healthcare representative. That would be a person who has the authority to make medical decisions on your behalf if you aren't able to do so. And with that appointment, the person has the ability to get all of your medical information from medical providers. In the world of HIPAA, hospitals and doctors are very, very concerned about protecting confidentiality, as well they should be. But a healthcare directive can empower your representative to get that information so that they can have effective communications and make appropriate decisions on your behalf. Among the other things you can take care of with a healthcare directive is provisions for a living will. It's your statement how you wish to be treated in the event of a terminal illness. whether you wish to have artificial life support systems or not. And you can craft a living will to say precisely what your wishes are in the event that you're not able to communicate because of such a grave condition. It's also an opportunity to indicate whether you wish to be an organ donor. And it's a document that you can use to designate a conservator should that need ever arise. But it's a very effective tool to avoid the need for conservatorship, especially conservator of person, because your healthcare representative can have effectively the same set of powers as a conservator would without the need to go to the court. You jump ahead just a little bit here. I'll come right back to that slide. I wanted to speak just a moment before I take some more questions and we adjourn our session for the day, to just talk about whether you need a lawyer for your affairs in the probate court. I get asked that question an awful lot. You may have heard the terms pro se or self-represented. That's how judges and lawyers describe individuals who are participants in a court case who don't have an attorney representing them. And I'm going to tell you that probate courts are very accustomed to self-represented parties. In fact, most probate court cases have at least one party who doesn't have an attorney who's representing herself or himself. So I'd say the probate courts are very adept at working with individuals who don't have a lawyer. And I'd say they're very helpful. They try to provide assistance and provide a lot of resources like pamphlets and a very robust website to give information to a person who is acting without a lawyer. Now, in most cases, there's no requirement of a lawyer. The only time the statutes say someone needs a lawyer are things like conservatorship. If you're the subject of a conservatorship case, someone has initiated a case saying you're not capable of handling your own affairs. As I mentioned before, the court will appoint an attorney for you because representation is critical and therefore required by law. But if I'm the petitioner in a probate case or a beneficiary of a deceased estate, as examples, there's no legal requirement for me to have an attorney. I would say whether you choose to have an attorney to represent you really depends. That's lawyer speak, isn't it? But it really depends on the particular circumstances. Some cases are customarily handled without lawyers at all. An example would be name changes. Guardianship of children would be another example. Rarely as a judge did I see lawyers representing people because it's really quite straightforward and most people are able to use the probate court forms for those cases without any difficulty. But the next issue would be the level of complexity. The cases vary greatly in that regard, but if there are tax issues or issues of potential liability on the part of the conservator, executor, or administrator, unusual assets, claims against an estate. Now, those are all things that might give rise to a need to have legal representation. And of course, whether or not the case is contested is also critical. In contested cases, I would say that most people would be well advised to be represented because there are so many complexities involved. The rules of evidence alone present a challenge that people without legal training would struggle with in most cases. And then another factor is whether it's the smartest and best use of your time. It's sort of like this. I think I could figure out how to fix my dishwasher if it broke down, but it may not be the wisest thing to do, and it may be a lot less expensive to hire the expert in the first place to get the job done right and have less leaking water on the floor while I'm trying to figure it out. You get my drift. Point is, though, feel free to confer with us if you have questions about that. I'm going to just go back one slide briefly to point out here that the Connecticut probate court system has a very nice website with a lot of information in it. It's ctprobate.gov. And I urge you to have a look at it if you have questions. There are some nice, what are called user guides that give you a pretty detailed description of the various case types and the steps that are involved in each of those cases. All right, I'm a little over on my time, but I want to see if I can address any last questions before we call it a day this morning. Okay. Let's see, we've got a lot of questions here. I'm not going to have time for quite all of them, so let me see which ones I can get to. Here's a question. Did you say you can't use small estate if there's any solely owned property or less than $40,000? So just a clarification on that small estate procedure. The maximum value of the assets is $40,000. Again, only the solely owned assets, $40,000. The other proviso being there cannot be solely owned real estate. So any other asset, if there's a solely owned bank account or a stock or bond, even a refund, that's fairly common, a refund check comes back in, let's say a rent deposit comes back in, all those are solely owned assets, and it can handle all those things as long as the aggregate value is under $40,000. But if the decedent had real estate in his or her sole name, then the small estate procedure doesn't work for us. One question is whether there's a way to name a beneficiary for real estate without using a trust. So the two primary methods of conveying real estate outside of probate in our state would be using a trust or joint ownership. So very common form of ownership, spouses and other relationships for real estate is joint with rights of survivorship. And that is a means of providing for that property to pass to the surviving owner immediately upon death when one of the owners passes away. One last question here. If your assets other than the house were settled outside of probate, are they still listed as public information due to the probate court fee calculation? Excellent question. And the answer is no. The information that is public in the probate court file pertains, pertains to the solely owned assets, those that are subject to probate. The estate tax return is the document by which the non-probate assets are reported, and that is a confidential document by statute, so that information is not subject to public information. All right, given the time, I think I'm going to call an end to our session together. It's been very nice to be with you, and may I say, our firm, Sapika, Daly, Pope and Perry, very fortunate we've been able to stay open during the governor's stay safe, stay home policy. We were talking about that before, but we've got systems in place where most of our staff are able to work safely from their homes. I, in fact, am at my home right now and making this presentation to you. But I do want to emphasize that we're here for you. We can help you. We are very happy to meet with you by video conference if that works for you. And hopefully we're not too far away from being able to meet with you in person. And again, our consultations these days are social distance friendly, and we'll do it over the phone or with video if that suits you. It's really been a pleasure being with you today, and I appreciate very much your participation. I thank you for joining me and hope that you have a great day today.